My name is Cesar Pereira. I'm a lawyer and an arbitrator based in São Paulo in Brazil, and I'm the immediate past chair of the Brazilian branch of the Chartered Institute of Arbitrators. And together with my colleague, Cristina Mastrobono, also a fellow of the Chartered Institute of Arbitrators and the vice chair of the CIRB Brazil Branch, we welcome you to our second session of the webinar series on the 2023 edition of the Willem C. Vis Moot. And we are very happy to have here with us our moderator, Paula Costa Silva, Professor Paula Costa Silva, and our speakers, Professor Ingeborg Schwenzer and Professor Edgardo Muñoz, both speakers, members, and in the case of Professor Ingeborg Schwenzer, a former chair of the CISG Advisory Council, which I'm sure all of you are very familiar with. We are delighted to have such a large attendance in this webinar. As you know, this webinar will be recorded and will be available at the CIRB Brazil Branch YouTube channel. And so I invite you to share that information with your colleagues so that people who cannot be here today online will be able to watch us later. That's the whole point. That's one of the great advantages of having now all this technology for events like this. And before introducing Professor Paula Costa Silva, our moderator, I would just like to point out that you will have the opportunity to ask questions to our speakers and to our moderator through the Q&A tool here on Zoom. So please feel free to use that and make your comments and ask your questions. This is a remarkable opportunity to be able to talk directly with our speakers today about these really intriguing issues of the Vis Moot this year. As you know, we had a first session regarding the procedural aspects of the case. That is also recorded and available on the CIRB Brazil YouTube channel. And today we will talk about the substantive issues regarding involved in the case. And for that, we will have as moderator Professor Paula Costa Silva. Professor Paula Costa Silva is a full professor at the Faculty of Law of the University of Lisbon. She is also a fellow of the Chartered Institute of Arbitrators. Has written and edited a number of books on procedural law and also substantive law involving a wide variety of topics. Professor Ingeborg and I were very fortunate to share with Professor Paula Costa Silva last year the task of editing a book about the CISG in Brazil and in Portugal, in celebration of the fact that Portugal just a couple of years ago joined the CISG and is now a member of the CISG family. And so I will turn to Professor Paula Costa Silva for her moderation of our exercise here today. But before that, I would like to just point out to you one more topic. Professor Edgardo Muñoz from the University of Guadalajara has organized for many years now a CISG conference, CISG and International Arbitration Conference, and a pre-moot in Guadalajara. That will take place next week, on Thursday and Friday next week. And as part of that, of course, you can join online the CISG and International Arbitration Conference. Just I think Professor Edgardo Muñoz will be able to put here on chat later the link for that information. But you can join the whole conference, but you can also join specifically a session that will be led by Professor Ingeborg Schwenzer and by Professor Louise Barrington, the director of Vis East, about the do's and don'ts of participating as a Moody in the Vis Moot competitions. And so they have been doing that for years now. That's very interesting, and I really encourage you, you all who are interested in the Vis Moot, to join that and learn from Professor Ingeborg Schwenzer and Professor Louise Barrington in that regard as well. So without any further ado, I would like to turn now to Professor Paula Costa Silva for our work here today. Thank you, Paula.
Thank you, Cesar. And thank you, and Cristina, for having me. It's a great pleasure. It's an honor to be here once again at the Ciarb branch, Brazil Ciarb branch. And I'm especially pleased because I will share this session with Professor Ingeborg and with Professor Edgardo. As you have told us before, we will focus today on the substantive issues that are raised by the Vis problem. And we will have a first presentation by Professor Edgardo Muñoz, who will address the issue of the drones and if the CISG should be applicable to this kind of, I don't know, of vehicles. But we will all learn with Professor Edgardo Muñoz. Professor Edgardo Muñoz is a professor at the Universidad Panamericana, Panamericana's law faculty in Guadalajara, Mexico, from where he frequently contributes to the global debate with specialized law books, journal articles, and discussion forums. Besides his academic commitments, he practices in the area of international contracting, arbitration, and sport law. He's a member of the CISG Advisory Council, correspondent of Unit 3 in Mexico, and an independent arbitration practitioner. So without no further delay, Edgardo, I will handle you the floor. Please, Edgardo.
Thank you, Professor Costa. Thank you, Cesar, Cristina, the whole Ciarb Brazil. It's an honor to be here together with my colleague Ingeborg Schwenzer, professor, mentor, and in particular to deal with the issues, the substantive issues of the Vis Moot of this year. I must disclose a few things. This year I'm not coaching any team. So when Cesar invited me to talk about the first substantive issue of this problem, I had to learn about it, and I really enjoy it. I was telling Ingeborg and Cesar, all here panelists, that I found that this year the substantive issues were not really explored in literature and case law, and therefore it made them a bit tricky, difficult, probably. Also for people like myself that even though I feel young, I have been in contact with this instrument, the CISG. So I have a presentation here that I hope will give us some ideas, and I hope also new ideas, in spite of the fact that you already have submitted your memoranda for respondent on how to address this issue, and probably new information that you did not have there. And obviously, this is the issue about unmanned aerial vehicles. We will refer to them as UAV and the CISG. This question is obviously a question about the scope of application of the CISG. That's how it's treated by the Moot case, and I think that's the logic. We have Article 2, which in letters E and also D exclude, well, in particular, letter E exclude what we may see as goods in principle. That's what they have in common: ships, vessel, hovercraft, and aircraft. But this is a prima facie impression, probably that they are goods, movable goods, that they are not immovable or real estate. We will see later on why. But that's what exclusion in Article 2E goods have in common. They seem like movable things. And so the question is whether UAV, which are not explicitly mentioned as excluded goods, constitute aircrafts in the sense of Article 2E. The question is not whether these vehicles are considered aircraft generally. That's not the question. The question is whether they fall in the exclusion provided by Article 2E. And I think this is important. The answer is provided by the convention itself. It's not what people generally think about drones or UAV and aircraft. What is the relationship? And this is the first thing we need to know. And with that in mind, one may wonder whether we care about the definition of UAVs in domestic laws. In the Moot case, we have in Article 1 of the Aviation Act of Ecuatoriana that UAVs of certain characteristics are considered aircraft. But in principle, we should not worry about it. And by the way, I have here the map. And for those of you who were wondering where Ecuatoriana is just there on the top of Portugal and Spain. So, but this should not be our starting point, what the law of Ecuatoriana is. Our starting point should be the CISG, as I mentioned. And so the outcome of whether drones are considered aircraft should be analyzed or depends on the interpretation of the concept of aircraft in Article 2. And this question is governed by the principles in Article 7. Article 7 provides the rules of interpretation for the convention test. And these principles are the following. Any interpretation should take into account the international character of the convention. This means that any domestic law or domestic understanding of a given word concept in the convention should not be the leading element or the most important element in interpreting, at least not the most important or the first one. And on the other hand, it means that an international understanding should be given to that term, to that provision. Second, the need to promote uniform application, which means that any outcome, any interpretation outcome should consider that the CISG needs to be uniformly applied within the more than 90 jurisdictions and beyond, because sometimes, as you know, the CISG is applied even in jurisdictions that have not adopted the CISG. And last but not least, any interpretation should be made observing good faith. Good faith is a very elusive concept, especially when it is about interpreting a legal text. But I think I understand it, and most people understand it, as a need to avoid an interpretation which is absurd or unfair, right? That it doesn't make sense. Well, these are our principles, but these are not, in part, this is not how we approach the interpretation. To interpret the CISG, we use methods of interpretation, which are obviously compatible with the principles, and we will know how they interact later on. And the most used methods that are compatible with these principles are those that you have there. I will try to unveil, or at least give clues to this question, whether drones are aircraft under Article 2E exclusion, using at least 3 of these or 4 of these methods. The first one, the second one, the fourth one, and the fifth one. The third one is not really used in the convention because methods of public international law, like the Vienna Convention on the interpretation of treaty, usually focuses on the interpretation of obligations between states. And the vast majority of the provisions in the CISG provide for obligations and rules applicable not to states, but between private parties. Probably only the last 5 articles will be public law provisions that would need to be interpreted and according to methods of public international law. But the rest of them, which are common also in legal systems, are relevant. And so let's start with the first one. The wording and systematic position. Article 2, it's an article that excludes either goods or rights, certain type of sales, or sales for a particular purpose, like consumer sales. So it has to be read very narrowly. If we take this into account, the systematic position, I mean, of Article 2 and the wording, a first thing that we can conclude is that as the name, drone or UAV is not there, it shouldn't be excluded. It only says aircraft. Now, things are not that easy, because if we study terms, we should wonder whether aircraft is the genus and a drone or UAV is the species of that genus. Take the example that I have here. If drones and aircraft, if, for example, aircrafts would be a food, let's wonder whether drones or UAV are actually a species of the fruit, or on the other hand, it's just a different food. If there is not the genus, sorry, if drones are not the species of a genus aircraft, we shouldn't exclude that from the convention. That's a first approach. But this approach has to be tested. The result has to be tested with the principles of interpretation. International character, need to promote uniformity and observance of good faith. And so you need to see whether that solution would comply with them. Second, drafting history, or travaux préparatoires, as they call it also with the French term. The first thing we can ask ourselves is whether the name or designation, the concept of UAV existed at the time of the enactment of the convention. That could be a starting point for the analysis of the history. Or what part of aircraft in the drafters, what part of aircraft has the drafters in mind? So if, for example, the name drone was not in the vocabulary of aircraft at the time, because as you may see here, a drone, I didn't know that actually, I just did my research. A drone is the male of the bees. If the drafters of the convention have in mind when they hear drone, a V, probably they don't they don't have this in mind, that they wanted to exclude things that would become later on drones. And that may be true, because if you see procedural order number 2, even in Equatoriana, the UAV's concept was only introduced in 2010, and the convention was drafted in the 70s. Now, this approach may not be necessarily the best one, because we have in the convention other provisions that have been interpreted in good faith to include other words or items that didn't exist at the time. The best example is Article 13 CISG, that says that in writing includes telegrams and telex. And there you have a picture of a telex. That's what they have in mind, the drafter of the CISG. Obviously, now most people agree that email falls into the category of items of Article 13, even if the drafter didn't have that in mind, okay? So let's continue with these ideas. Now, the drafters, when you look at the travaux préparatoires and the first commentaries, especially Honor and the Secretariats, discuss more ships than aircraft. And then they actually did the analogy most of the time with ships and boats, which are also in vessels are excluded from the convention. And so the question is whether we need to take into consideration that the drafter discussed with regard to vessels, to figure out whether drones will also have those problems of vessels and ship and boats. And I want to say from now that what worries them at that time was that some vessels and aircraft, and these already probably require registration. And they said that these probably interfere with the CISG provisions. Later on, we will see whether this is actually completely true or not. But let's see. This is what the Secretariat commentary stated for the New York draft in '76. This is years before the enactment of the convention on the 80s. This means that this provision was there in the early drafts, and we will see why. They said that in movables, that vessels and aircraft are assimilated in some countries as immovables, and that at least some ships and aircraft are subject to special registration requirements that may differ in different countries. And as they differ in different countries, it was probably better to exclude them from the convention, because they were not sure how they would, as I mentioned, this requirement interferes with other provisions of the convention. This is an early version of the convention, 76. And having that in mind, which is what is mostly discussed in commentaries, and I must say that the major commentaries are very brief on this question about drones or UAV. I checked, for example, Schwenzer commentary, and they have in one line, drones obviously do not fall into the category of aircraft, period. But that's it. That's it. But it doesn't give more. Also, the Brunner Gottlieb commentary, they say, probably drones, at least those who can carry people, do not fall in the convention exclusion, but that's it. Most commentaries are very brief on this question. Now, if we have in mind what the Secretariat's commentary said at that point, does it matter how a UAV looks like and what may it be able to carry? Probably this is not relevant, because what it worries them was the registration requirement and that it was considering some domestic laws as immovable. Obviously, the case problem give us information about this. And probably the case problem tell us all this because of the requirements under Equatoriana law, certainly. But we said at the beginning that maybe we should not worry about domestic law, at least. We shouldn't consult that directly on the first place. So this is just a question that I leave there. If we take this into consideration, how it looks and how what it carries, we may not get to achieve uniformity because some courts would say, oh, certain kilograms or tons higher fall in the CISG, others are excluded, right? It doesn't make sense, probably. Now, does it matter that the drone in question or the UIV vehicle is remotely operated? Well, from the drafting history, probably it matters because in the 70s, the drafter probably could hardly believe that some planes would be able to be flying over there without pilots, right? So probably this is a question that could lead us to say, well, drones do not fall into that exception because the drafter didn't consider that. They were considered things that were piloted by people, not remotely from the ground. Now we turn to comparative law as a method of interpreting the CISG, as I mentioned. And here, obviously, the Equatoriana safety aerial statutes become relevant. And that statute assimilates at least the drones that claimants are selling as aircraft. But then PO2 tell us that that's not necessarily a uniform solution around the world because there are other jurisdictions that do not require registration and probably do not consider drones aircraft. And so this gives us some material to discuss whether domestic law provisions give a uniform answer and whether we should rely on them, at least on some of them. Actually, I don't have the answer to this. It's just some material to think about. And then use of uniform projects. And this is the most interesting. Now I know why, after some research, and you will know why, the first draft had the exclusion of aircraft. It's because in previous uniform law, which is prior to the CISG, which was the uniform law for the formation on contract, the ULFIS, aircraft was excluded from Article 1(6)(b). But at that point, it says ships, vessel, aircraft, which is or will be subject to registration. As you know, this instrument was considered by the drafter of the CISG, actually was one of the starting points for many provisions. But then I went deep into the drafting materials, and I saw that the delegate of Mexico, my country actually, who was actually the chair of this working group, at least on that session, mentioned that the part of it that says subject to registration didn't make much sense because it would give to domestic law the solution as to whether one particular good would be or not covered by the convention. And he says, I think rightly so, this should not be the case. The convention should set itself whether a particular good falls into it or not. And they recommended to delete it completely, that phrase, and only to leave ship, vessels, or aircraft. if they wanted to exclude them. I read this like, as is the delegate of Mexico was also of the opinion that it shouldn't be there, actually, the exclusion of ship, vessels, or aircraft. But he says, in any case, if you want to leave it there, you should delete that thing of subject to registration, because it will depend on domestic law dissolution. What came after, I read more of this material, was something very interesting, which made me wonder whether the registration requirement was really a concern for the drafters of the convention. Consider Article 4A, Article 11, Article 30, 41, and 42. I tell you fastly what are these articles about. Article 4A says any issue of validity is excluded from the convention unless it's expressly provided. One issue of it is expressly provided is the issue of formal validity, that contracts are not needed to be in writing under the convention. You do not need a writing under Article 11 to have a contract in the convention. So that's an issue of validity that is covered by the convention. The rest are not covered. And then you have Article 4 as well tells us that the convention is not concerned about the effects of transfer of property. It doesn't deal with whether property has passed or not, at what point, and whether someone can sell goods that are not owned by. A seller can sell goods that he doesn't own. And then Article 30 tells us that the seller must deliver the property of the goods. Article 41 says the property must be clean. And 42, the same, must be clean about IP issues. And this question came to my mind every time I read it, until I found this. There was the comments of Finland that says, and these comments that I will read in the next 3 slides are like the dissenting opinion. This is what is not in the text, but may help us with the question of drones. There was Finland that says ships and aircraft in principle are subject to the same rules under national law for sales, equal to other goods. We should not exclude them. Any requirement can be dealt is dealt by mandatory rules that do not affect probably the convention. And then we have the same Philippines saying the same. Ships and aircraft should not be excluded. The exclusion of ships and aircraft from the application seems unjustified. The general provisions of the convention may be applied to them, subject to special requirements imposed by special laws. And then we have together Finland, Norway, and Philippines saying the same, saying that they did not agree with that they should delete the exclusion in E of that draft, or alternative, Norway say we should put a cap on the gross tonnage. Later on, that proposal came into the comments of the Secretariat and said, there is some, in view of, is comment 7, I would say. In view of the dispositive character of the convention and its non-application to questions of validity, mandatory law, there seems to be no need to make exceptions for vessels and aircraft. And it says the best and simple solution is to make no special exception and not imposing this requirement proposed by Norway. And I think that they were right, the minority, that this exception should not exist, because what I understand after reading some of, at least from my region, the registration requirement for vessels and ships an aircraft doesn't affect it's not a question of formal validity. The convention can still apply. It doesn't say that if there is no registration, there is no valid contract. What they said is that if there is no registration, property may not pass to the buyer. And so there will be no clash with Article 11 problem. And as the convention doesn't lead with the effect on the transfer of property, probably we could still have the convention ruling on those matters, even if requirement is something that is required under some national laws. But obviously this is only my idea. And that was the view of the minority opinion, the dissenting opinion of the drafters. Now, why is this relevant? Probably this is relevant, this dissenting opinion, to say we should not exclude drones. Okay, aircraft is already there. We can do very little about it. But we should not exclude drones for several reasons. And these are some of the reasons. Maybe I'm wrong. And this, as a respondent, all this material is used to say, look, some minority tried to delete that exclusion and they were unsuccessful. Everything falls into the same category of aircraft. And last, I was wondering if, and this is particular to the moot case of this, year, whether there was, in spite of the question whether drones are excluded, whether there was an opt-out, because apparently in the communications between the parties, they always refer indistinctly as aircraft, the goods that they were dealing with, they were negotiating. Or on the other hand, whether there was an opt-in, whether there is any elements in the case file to say that irrespective of the fact that drones would be excluded, the parties intended them to be governed by the CISG. And that's it. Thank you very much. These are only some ideas for thought. Obviously, I'm talking under the control of Professor Schwenzer here, who is the expert. Thank you.
Thank you. Thank you, Edgardo. I think your presentation was really stimulating and defying. We will have questions after we have Professor Ingeborg, but I think the point you stressed, and you gave us many hints for getting a solution for the case. I think the point you stressed was the importance of the registration and the consequences of registration under domestic law, and the collision between this requirement and the applicability of the convention. But we will come later to all these questions and others that will be addressed to you by the audience. And I have now the pleasure to introduce you Professor Ingeborg Schwenzer, a good friend, if you permit me. Professor Ingeborg Schwenzer, who is known by everyone, is a Professor Emerita of Private Law at the University of Basel and Dean of the Swiss International Law School. Professor Ingeborg is editor of the most important commentary, I would say, of the Bible on the CISG, and also a member to the advisory board of the CISG. With Edgardo Muñoz, Professor Ingeborg is co-author of Global Sales and Contract Law, which can be considered, I would say, without any doubt, the most comprehensive work on international sales law and practice. Professor Ingeborg, the floor is now yours.
Thank you so much, dear Paula, for this very kind introduction. And I wanted to thank Cesar and Christina for inviting me to this very interesting talk on this year's moot problem. Let me bring up my slides. Just a second. There they are. They should be. Screen sharing failed, it tells me. No.
Now it's working.
Okay, yeah, there we go. It's working now.
Mm-hmm.
Okay, I will talk about the second topic of this year's moot problem, the CISG and concurrent domestic remedies. And I expanded it a bit. I will not be only talking about CISG and domestic remedies on misrepresentation, but I will go a bit further and discuss the general problem of concurrent domestic remedies. So I will start with some examples. The first example is not taken from the moot. None of these examples is taken from the moot problem, actually. But imagine that was actually a case I've been involved in, an international arbitration that took place last year. A buyer alleged that it was mistaken as to the pure value of the goods. Under Article 35 of the CISG, the seller was not liable as all features that were agreed upon in the contract were present. It was just that the buyer was mistaken as to the value of the goods. And now the question arose, although there was no remedy under Article 35 CISG, may the buyer still rely on mistake under the otherwise applicable domestic law? So that's my first example, an Article 35 CISG example, which is also the basis for this year's moot problem. Next example, the buyer did not inspect the corks that the seller delivered. And now the question is, may it rely on a domestic tort remedy if the corks spoil the wine in the bottles due to the defective corks? It's again a 35 question, Article 35, because the buyer in that case lost its remedies under Article 35 because it did not inspect the corks and thus did not notify the seller of any non-conformity of the corks. Thus, under Article 39, the buyer has forgone all remedies under the CISG. And now the question arises, may the buyer rely on domestic tort remedies because the corks spoiled the wine, that means property of the buyer? My third example, at the time of the conclusion of the contract, the goods did no longer exist. So there were no subject matter of the contract. May the buyer rely on initial impossibility and recover the purchase price, although the CISG remedy would fail? So again, under the CISG, no remedy, could the buyer rely on a concurrent domestic remedy? In that case, initial impossibility, and ensuing from that probably a claim for unjust enrichment if it had paid the purchase price. So what is our starting point? Our starting point is Article 4. And we look closely into Article 4 now. This convention governs only the formation of the contract of sale and the rights and obligations of the seller and the buyer arising from such a contract. In particular, except as otherwise expressly provided in this convention, it is not concerned with the validity of the contract or of any of its provisions or of any usage. The second exception, namely litera B, was already mentioned by my dear colleague, Professor Muñoz, namely the effect which the contract may have on the property in the goods sold. So, and this defines the scope of the CISG. The core scope are rights and obligations arising from the contract. Not covered are, as we saw, according to Article 4, Sentence 2, litera A, validity question. The validity of the contract is not covered. But also, as Article 4 speaks about rights and obligations arising from the contract, it is clear that the CISG does not cover tort remedies. That was my second example, the example with the corks, the question, may the buyer rely on domestic tort remedies? And likewise, also arising from the wording of Article 4, namely, this convention governs only the rights and obligations arising from the contract. It is clear that procedural questions are not covered by the CISG either. So it's only the contractual dimension of the relationship between the parties that is covered by the CISG. However, we see in Article 4, and Professor Muñoz also mentioned it, that there is a counter exception, namely, except as otherwise expressly provided in this convention. And the question certainly is, when does the CISG expressly provide for the regulation of a certain scenario? If we go to domestic laws, we will see that there are different conceptions. There are different conceptions regarding validity, like with questions of initial impossibility or mistake. There are different conceptions regarding the borderland between tort and contract. So under some legal systems, something might be conceived as being a tort. Under other legal systems, a tort remedy is denied, and the buyer in a certain case is only left with contract remedies. Also, the same applies to the borderland between substantive law and procedure. What might be perceived as a substantive question in one legal system might be conceived as a procedural question in another legal system. So the crucial question, and that was also already at the core of Professor Muñoz's presentation, the crucial question is, how do we define the areas that are outside the CISG and that are left to the otherwise applicable domestic law? And we have to decide this, and that resumes what Professor Muñoz has already said, by relying on Article 7 of the CISG, namely, how do we interpret the CISG? How do we interpret Article 4, which provides for the scope of the CISG? Article 7, para 1, has especially 3 prongs. The one is that we have to rely on the international character of the CISG. The second one is the need to promote uniformity. And the third one is the observance of good faith in international trade. So what are the consequences? All these criteria to interpret the convention have one overall aim, and that is uniformity. It was hard to achieve uniformity in the first place. We now have it with the CISG, and by interpreting the CISG, we have to strive for the highest degree on keeping this uniformity. And that leads to the following consequences, namely, all the provisions of the CISG must be interpreted autonomously. They must be interpreted out of the CISG itself without relying on any domestic interpretation, even if the domestic law contains similar terms like the CISG, we might not rely on the interpretation of the domestic legal system, especially not rely on any case law that is interpreting the domestic legal system, even if we have similar wordings, like, for example, if we are dealing with the term of fraud. So how is this autonomous interpretation be achieved? Well, also Professor Muñoz has named some ways of interpretation, and he has also named the comparative law approach. If the CISG itself does not explicitly interpret a term, like, for example, fraud or the like, then we might turn to comparative law and ask ourselves, what is the common core, the general approach to interpret a certain term? Let me now come to the question, if we go back to Article 4 of the CISG, we saw a question is left to domestic law if it is not expressly provided for in the CISG. And the question is, what does that mean? Except as otherwise expressly provided. What does expressly mean? Well, certainly the CISG does not tell us what is a tort or what is a fraud. We don't have any definition of these terms, but we can still rely on Article 7, Para 2, that tells us questions concerning matters governed by this convention, which are not expressly settled in it, are to be settled in conformity with the general principles on which it is based. That means when we look into Article 4, Sentence 2 of the CISG, and we have to decide what is expressly provided for in the CISG, we may at the same time look into the general principles of the CISG under Article 7, Para 2. And if a situation is either expressly settled in the convention or can be determined by relying on general principles of the CISG, then it is otherwise expressly provided in the CISG. Next question. If we go back to the counter exception in Article 4, Sentence 2, when is the CISG providing for a situation? We have to ask ourselves, what is the factual situation that is giving rise to a remedy under the CISG? And if the CISG is regulating a certain factual situation, and this is the same situation that gives a remedy under the otherwise applicable domestic law, then the CISG is providing for a certain situation. And then one can imply that the otherwise applicable domestic law remedy is excluded. Furthermore, we have to ask the question, what is the legal purpose of the otherwise applicable domestic law, and is it the same as that of the CISG? If the purpose are the same under the CISG, for example, giving the buyer a remedy in case of non-conforming goods, and the purpose is the same under the otherwise applicable domestic law, then domestic law must be excluded. So if we have the same factual situation that gives rise for a remedy under the CISG and under the applicable domestic law, and if the legal purpose of the two regulations, the CISG and the otherwise applicable domestic law, is the same, then the CISG preempts domestic remedies. Any other solution would undermine uniformity because it would render the solution to domestic law and to the definition of a certain term under domestic law. Let me now come to my examples, and that is your example under this year's Vis Moot problem: mistake, negligent, misrepresentation. If we look into domestic legal systems, we find, especially in civil law legal systems, that mistake remedies may be used concurrently to sales law remedies. In some legal systems, however, if there are sales law remedies, then concurrent remedies under the likewise domestic law for mistake are excluded. So this is mostly the civil law approach, to rely on mistake with regard to the subject matter of the contract. In common law legal systems, the sphere of application of mistake is much narrower, and common law rather relies on negligent misrepresentation alongside sales law remedies. In the CISG, we have the matters referred to in Article 35, conformity of the goods, 41, the question of ownership in the goods, 42, the question of intellectual property rights. Whenever domestic remedies, be they relying on mistake or on negligent misrepresentation, belong to these questions and relate to these questions, that means conformity of the goods, ownership in the goods, or intellectual property rights, that is the same factual situation that is covered by the CISG, and thus domestic law remedies should be excluded. Furthermore, matters referred to in Article 71 through 73, like deficiency, inability to perform, 71, or anticipatory breach, 72, or installment contracts under Article 73, likewise are factual situations covered by the CISG, and domestic remedies for mistake, negligent misrepresentation in these cases should be preempted. Mistaken declaration, that is especially an approach found in civil law legal systems. There are different domestic solutions: unilateral mistake, common mistake. Again, civil law legal systems are much more generous in allowing mistakes in declaration than common law legal systems. In the CISG, these factual situations where a party is mistaken as to its own words, these factual situations are covered by Article 8 on interpretation and Article 14 and following for formation of contract. Likewise, a mistake as to the identity of the other party would also be covered by questions by Article 8, interpretation or formation of contract. Thus, also in these cases, mistake in declaration, domestic remedies for mistake, and negligent misrepresentation should be preempted by the CISG. Last point, let me turn to initial impossibility that I mentioned. What happens if at the time of the conclusion of the contract, the subject matter, the goods do not exist at all or any longer? The question under domestic legal systems, in some legal systems, the contract may be void if at the time of the conclusion of the contract, the subject matter does not exist. The question is, does the CISG provide for this factual situation? And we do have a provision in the CISG, that is Article 68, where the question of risk of loss is regulated if the goods are sold in transit. That means on the way to the buyer, and where the goods have already been destroyed or lost at the time of the conclusion of the contract. And that means the CISG has a general principle on which we can rely, that regulates, that provides for this factual situation, and thus initial impossibility should be excluded by this general principle of the CISG. Likewise, in some legal systems, a contract may be void if the subject matter, if the goods belong to a third party at the time of the conclusion of the contract. Again, this situation, this factual situation, is regulated in the CISG in Article 41, and it is clear that the contract under the CISG is not void because the seller is liable if it is not possible that ownership is transferred into the buyer. Thus, in all these cases, domestic remedies for initial impossibility are preempted because the CISG is providing for this factual situation. Let me now come to my example concerning tort law, property damage. In some domestic legal systems, tort law remedies may be used by the buyer in case of damage to the chattel itself. That means the goods that have been sold destroy themselves, or where damage is caused to property which is attached to the goods, or with which the goods are combined or commingled, or which are processed by the goods in the normal course of business or the course of normal use. So we have a group of legal systems that allow tort law remedies in these cases. In other domestic legal systems, there is no tort remedy, rather the buyer is confined to contract remedies in these cases. Thus, if we were to allow again the otherwise applicable domestic law to define what is a contract law remedy and what is a tort remedy, this would lead us to a non-uniform application of the CISG. And therefore, in these cases, domestic tort remedies where property damage is a natural consequence of the defect must be preempted. And my last example is procedural law. In some legal systems, especially in the US, for example, post-judgment interest is treated as a procedural question. In other legal systems, especially in civil law legal systems, post-judgment interest is treated as a substantive law issue, just like prejudgment interest. Likewise, under the CISG in Article 78, there's no distinction between pre- and post-judgment interest. And therefore, if we were to allow a rule like in American civil procedure that post-judgment interest is to be dealt with under procedural law, this would undermine uniformity under the CISG. Therefore, domestic procedural rules on interest must be preempted. And now my last slide. So where can we apply domestic law remedies alongside the CISG? And if we remember, the core point was the question whether the same fact situation is regulated by the CISG and by the otherwise applicable domestic law. And then we have to ask, well, if there is fraud, fraud would be a different fact situation than the one regulated under the CISG, especially in Article 35, but also in other provisions of the CISG. But now we have to ask, what is fraud? And we may not leave the answer to this question to the applicable domestic law, but rather we have to define fraud under the CISG. And as we do not have a definition, we have to turn to comparative law and to ask what is the core in domestic legal systems. And also Professor Muñoz mentioned it. We may rely, for example, on other international sets of rules, like the UNIDROIT principles, but not like the UNIDROIT principles defined or interpreted by a domestic court, but from their intended by their drafter. And there we may find a definition of fraud, and then these cases may be dealt with also under domestic law, under the domestic law of fraud, which in most legal systems is also a tort remedy. Tort law in case of damage to property that does not necessarily come into close contact with the goods, property of the buyer, is going beyond what is regulated in the CISG, and thus tort remedies may be relied upon by a buyer in case of damage to property other than the goods, or other than goods coming in close contact with the non-conforming goods. Procedural rules may be relied upon where the CISG does not regulate the matter at stake. So, for example, also for the question of attorneys' fees. Where domestic remedies are allowed, where they regulate a factual situation going beyond the one of the CISG, they may be relied upon alongside the CISG remedy, and the buyer or the obligee may rely on either of them, the CISG or the domestic law remedies. And this concludes my presentation. Thank you very much for your attendance.
Thank you, Ingeborg. What an enlightenment presentation. If I could draw a conclusion from both your presentations, I think the most important aspects to stress is that the first task of the applier, of the interpreter, is to switch off the button of his domestic law, of the pre-comprehensions any of us brings from our education, from what we do usually every day, and try to grasp the scope of application of the convention in a very, very autonomous way. So as Edgardo and you, Ingeborg, you stress this point. We have to recur to other international legal instruments if we don't have definitions in the CISG, as we have to do with any international instrument. We cannot go to our domestic law and try from our domestic law to bring concepts and interpret the concepts of an international instrument who was thought exactly to provide a solution that is distinct from any solution of any domestic law. Cesar, I would, Cesar and Cristina, do we have questions from the audience?
Yes, there is one question for Edgardo regarding the drones here. Edgardo, can you read the question here?
Yes.
Okay.
And don't you think, Cesar, it would be better that we would see first the questions of the audience, and if there is time, we could discuss.
This is a question from the audience, from Eduardo Jeitas. And I will just read it out loud, and so that it's on the record. The question is the purpose of the drones given by the parties relevant to interpret if they fit under the exclusion of Article 2E CISG? In this, okay, well, the question was answered, I think. That appeared to me. Okay. In this sense, if the parties interpret the exclusion of Article 2E according to the assigned purpose of the goods, would that undermine the uniform applicability of the convention? So, Edgardo, if you want to address it. And actually,
Yes,
Ingeborg, maybe it would be interesting for the two of you to comment on questions regarding the others presentation, so that actually we have both of your views on the two topics.
Okay, well, I will try to answer first, and then Ingeborg can supplement or correct. I think that yes, that approach would undermine the uniform application. I mean, the intention of the parties would be relevant, but outside the concept of aircraft in Article 2E, just to see whether they wanted the convention to apply, in spite of the fact that what they may be selling was excluded. So that is not that the intention is irrelevant. It may be relevant for an opt-in of the convention, but I'm not sure that we should interpret the concept in the convention having regard of the party's intention. We can actually interpret the contract and see how it fits with what they intended with regard to the CISG, but not the convention. That would be my answer.
Ingeborg.
Yes, first of all, I wanted to thank Professor Muñoz for his presentation, and I will follow Cesar's question to to add some remarks on Professor Muñoz's presentation. I entirely agree, and I think, Edgardo, you pointed out the different mechanisms how to interpret the convention, and I think it's very important also to look at the reason of the travaux préparatoires. Why did they exclude it? And is it today, does it make sense today that we still have this exclusion? Should we interpret it narrowly or broadly? Yeah, and I think you did a great job in showing us how each side can use this argument for its own client to support the position of claimant or of respondent in this case. And I think it's a very good example. And Stefan Kröll has done a great job again in drafting the problem so that each side may elaborate arguments that can support their own position. I think it's a great thing to do. And well, probably if I had to decide the question today, I would also always, but I'm a pro CISG person, so everybody knows about that. And so I would interpret the exception very narrowly. And that's why I certainly wouldn't interpret it as encompassing drones now. So, but that's in the end up to the adjudicator. But I think what is important now in this stage and for our students is that they can use the arguments for both sides, yeah, as claimant and as respondent, and you worked it out very nicely what arguments there can be used and how they can be used.
Paula, I just have
Ingeborg, we have many questions, Cesar.
Yeah, I just have a follow-up question on that point. I thought it was really interesting what Edgardo said at the end regarding implied opt-in, because I just wanted to make sure the parties can obviously opt into the CISG in cases in which the CISG would not be automatically applicable, right? And I understand they can do that also regarding the exclusions, right? And so they would be able to by agreement to apply the CISG even to a sale of an aircraft, right? And in that case, it becomes really relevant to understand what the parties defined as being the drone, or of course, if we consider that drones are per se excluded, then that's not a problem. But even if you don't agree with that proposition in the beginning, it's possible that the parties will, by the language in their agreement, will have, and by their exchanges, will have impliedly opted into the CISG, even in that situation, right? And so I just wanted to confirm if that's what you meant, because it seemed a very interesting point for the teams to address when they're discussing this issue.
Yeah.
Paula, yeah, you were going to ask some other questions.
I had a follow-on comment on Ingeborg's last intervention. I fully agree. We have to interpret these exceptions very narrowly. And when we think that, for example, does the sale of a train, what would we do with the sale of a train and with the sale of a car? In my country, for example, there is a registration for the sale for a car. So should this item be so important why are cars on the CISG and subject to register, and other goods not subject to the CISG? So it would be, I think it would be a very dramatic intervention of the domestic law on the definition of the scope of application of the CISG. And I think this we cannot allow. So I would agree with both of you. Let us interpret these exceptions very narrowly and try to understand what was the scope of the exclusions under Article 2. So, Cesar, I will go to the questions of our participants, but I'm not very skilled.
Oh, okay, I can do that.
Could you read the questions,
yes,
Cesar?
Yeah,
We have
no
8
problem.
questions now.
Yeah, I have all of them open here. I just again just follow up in what Paula said. Now, I thought it was interesting to think when Edgardo was talking about what had crossed the drafters' minds when he showed the telex machine and things like that. But I think it's interesting to know that remember that many flying objects that were not aircraft or that were not immediately thought of as aircraft existed already in the 70s and the 80s, like those toy aircrafts, for instance, controlled by radio or controlled by wire. All these hang gliders. There are many things that fly that are not necessarily seen as aircraft, and so I think all of that goes into the direction that those exceptions, the aircraft exception, should be interpreted narrowly, because it seems that the convention drafters opted for something that was more specific than any flying object, right? And but again, no, let's go to the questions here. I will take them in order. So we have an anonymous attendee that asked, why are immovable goods incompatible with the CISG? Ingeborg, would you like to comment?
Yes, again, it was, well, 2 points. First of all, in most sales laws, in common law jurisdiction and in civil law jurisdictions, goods are defined as being tangible, movable goods. So that would have gone much too far. And actually there was no need for unifying the law on the sale of immovables, because immovables are not crossing the border. Yeah, so that is a big difference between movable and immovables. And then there are special rules for immovables again. And it's again the registration point that brings them close up, that brings aircrafts and vessels close to immovables in many legal systems. And in many legal systems, there's even a definition that an aircraft or a vessel is an immovable, yeah, because there is that registration requirement. So that is to come around and to bring in the definition of aircraft and vessels again. But I think that was the starting point for never ever thinking of immovables. And if you take, for example, the common law countries and the Sale of Goods Acts or the Uniform Commercial Code, they only relate to movables, never to immovables.
Yeah, well, that's a very interesting point, and it seems obvious, right, that immovable goods would not be subject to international sales. But on the other hand, there are, as you said, there are many domestic regulations about that. Also, in terms of national interest, there are many countries that even prohibit foreigners from owning immovable goods, and so it's very interesting. Well, Edgardo, we'll try to cover the questions quickly here before we have to close. The next one is, would it be prudent to look to international aviation instruments in defining aircraft? Since they are internationally available, perhaps they would not affect uniform application as much.
Yes, I think this is a good idea, to look at definitions from international bodies that have, in a way, gathered the solution or the definition that would be taking into consideration different approaches. That's always a good idea, but obviously testing that result with the principles of the conventions that we already mentioned are in Article 7.
Okay, thank you. And Ingeborg, Ani Tavkilidze asked a question here. I have a question regarding the fraudulent misrepresentation. According to the case law, most of the time, tribunal resolves the issue under the domestic law rather than the CISG, due to the fact that the convention does not deal with the validity of the contract. Would you say that this approach is reasonable?
I think it is reasonable, but still the question, what is fraud? Is fraud has to be autonomously defined by the CISG. And it's not possible that a domestic legal system suddenly says, well, any mentioning of a feature in the contract that is not present in the goods constitutes fraud. By this, you could undermine the CISG and there would be no uniformity anymore. So what is fraud has to be defined autonomously under the CISG and thereby following a comparative approach. What is fraud in a comparative view in the majority of legal systems?
And Ingeborg, since you have the floor, just one more question. Jim Han has asked, does Professor Schwenzer's function test apply here to determine that the UAV is not an aircraft?
I think it shouldn't be applied to the interpretation of the term aircraft. It's not related to that function. We ask the question, what is the function of a rule? Which factual situation is covered by a certain rule under the CISG? And is the same function fulfilled by a domestic remedy, for example? But I think it cannot be used to interpret the term aircraft.
In Edgardo, Angela Lynn Atti is asking here, do you have any advice on how to tackle the question of what constitutes a new product, as in for the Hawkeye 2020 to be considered as the newest product, which is part of the discussion about the misrepresentation? Does it have to be released on the market first?
Well, that's actually, yes, it's on Ingeborg's part, that question. Well, go ahead, Ingeborg. Yeah.
It's a question of the interpretation of the contract. Yeah, you have to look into the contract, and according to Article 8, as you probably cannot find the true intent of the parties, then you have to look what a reasonable person would have understood by what the parties negotiated and what went into the contract, also the purpose of the goods, and whether the use that the buyer wanted to put the goods to can be fulfilled by either of these goods. So it's a simple interpretation of the contract.
Yeah, and in addition to that, I think is a question whether the seller, under the circumstances, had the obligation to disclose or not, and whether this is something addressed by the CISG. because that's an issue, whether he had the obligation to disclose.
Okay, thank you. And there are two questions about registration here, and I will read them together, and so you can address them. First one says, the requirement of registration was removed when the CISG was imported from the predecessor ULIS. Does this suggest that individual states' presence or absence of registration requirements is irrelevant? So that's the first aspect. And the second one is, why are registration requirements specifically incompatible with the CISG? The committee report speaks of specialized national legislation and how these are incompatible with the CISG as well, but does not shed light on why. Is it because these involve matters of state sovereignty? So,
well,
anyone?
Yes, I want to try what I understood from what I read. I want to try to give an answer. First is indeed the ULFI, I think it's called ULFIs, right? Or the
ULIS.
ULIS?
ULIS, yeah.
Well, it was in the part of the formation, so I don't know if it is ULFIs. Yes, ULIS or ULFIs.
Okay.
Yeah, had when they are required to register. And so apparently they deleted that part and said, we don't need, if we leave that, there is not gonna be uniform solution. Either we strike the whole exception or we strike that last part, because otherwise it will depend on the sellers or the buyers' requirements on registration. And I think that, and they decided to just leave it without the registration requirement. And apparently any aircraft, any ships, vessels would be covered by that exception. But at least all the items they had in mind at that point. The commentary said, oh, well, small boats, blah, 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 aircraft, which is, but we don't find that reasoning in the travaux préparatoires. And what I believe worries them was that some of these delegates understood that the registration requirement was a formal validity issue, and that would clash with Article 11, that doesn't require formal requirements. But I think that probably was a misconception of the time, because the registration requirements are actually related with moment of transfer of property. I don't know if you agree or want to supplement, Ingeborg.
Yes, I agree entirely, yes.
And I will read now, before we close, 3 questions that have to do with fraud. I'll also read them together and you can comment. First is, with respect to fraud, should we draw a distinction between using the unit draw principles and domestic statutes based on the unit draw principles in gleaning what fraud is? Will there be a significant difference in the uniformity of applying the CISG? The second aspect is, as regards to the second issue of merit, is there an instance in which the CISG's remedies for fraud, assuming there are any under an autonomous interpretation of fraud, could be applied in exclusion of all remedies in the domestic law? And the third question is actually just a clarification here. Annie, who asked the question before, asked to clarify, the term fraud has to be defined under the legal systems. I imagine the domestic legal systems. Am I correct? And sorry, I'm making a confusion here. But, yeah, please go ahead. Because we have 2 more questions about fraud now. Please go ahead, Ingeborg, if you can comment on these.
Well, regarding the first question, if we have the UNIDROIT principles as an international set of rules and the UNIDROIT principles as a domestic law, as I understand the problem, the Supreme Court of Equatoriana has interpreted the domestic law in a certain way that would not be necessarily the interpretation of the international set of the UNIDROIT principles. So if we look at the UNIDROIT principles, actually, I think we can use the UNIDROIT principles within the comparative law approach, because they are an expression of living comparative law. So we look into domestic legal systems to look how is the majority of legal systems defining fraud, and we may also use the UNIDROIT principles to define fraud autonomously. But that is something different than if the Supreme Court of Equatoriana, applying the domestic UNIDROIT principles, has interpreted them in a certain way. So yes, UNIDROIT principles as an international set of rules, and with the interpretation given by the drafters, or if we have case law on the international set of UNIDROIT principles, but not the interpretation of the UNIDROIT principles by a domestic Supreme Court. That is something different. What was the second question? It was...
well, the last one was whether fraud has to be defined under domestic law.
Now, that is undermining uniformity.
Yeah.
Fraud has to be defined autonomously under the CISG, and one of the ways to do that is by comparative law, by the comparative law approach, which includes the international set of UNIDROIT principles, but not the definition by one Supreme Court that is not followed in any other legal systems. Yeah.
Yeah.
But,
thank you. And I guess just one final question about this topic, one that came later by Fernando Mentoni. Is the fraudulent misrepresentation of a party always comparable to bad faith? In this sense, how can the CISG preempt a remedy for fraudulent misrepresentation if good faith falls outside the CISG scope of applicability? I guess it has to do with this very controversial issue of how good faith enters the CISG and how it should apply, and how that interplays with the idea that misrepresentation generally involves a breach of good faith in one aspect.
Well, first of all, we agree, or most of the commentators now agree, that good faith is not a standard to be applied for the behavior of the parties under the CISG. It is to be applied for the interpretation of the CISG. And again, I think everybody agrees that fraud is outside the CISG, and that an aggrieved party aggrieved by fraud may rely on the otherwise applicable domestic law remedies for fraud, be it a tort in the relevant domestic legal system or not. But the main question is, how do we define fraud? That is the point. And if it is something that goes beyond the presentations, for example, that are made in every and each sales contract, and that give rise to conformity under Article 35, if it goes beyond, and if there is fraudulent behavior, then the buyer may rely on domestic remedies. The main question is, what is fraudulent behavior?
Thank you. Well, actually, we keep getting more and more questions here now. And so, but we are already past our end time here. And so I will turn back to Paula. And Paula, so if you want to make some closing remarks, and then turn to Christina to close our event, because about the questions. We will record all of them here, and we will send them to the speakers. And if we are able to answer them in writing, we will try to share that information with all of you afterwards. But well, and I again, before I end my participation here, thank you, Ingeborg, thank you, Edgardo, and thank you, Paula, again. This series of webinars was an idea originally from Christina, and I thank her also for this excellent idea and for putting this together. It has been a wonderful opportunity in both these sessions to address in depth all the moot problem issues, and I'm sure one of the greatest advices we can give to everyone participating is to see and watch and see again these recordings, because they are very valuable to the main purpose of the moot, which is education, which is learning from this experience. And so I could not thank you enough for your time, Ingeborg, Edgardo, and Paula, in participating in this. So thank you.
Cesar,
Yes.
I share in the chat the do's and don'ts session by Professor Schwenzer and Luis Barrington, but I think that didn't reach the students here. It only reached the speakers. But in any case, I sent it to you by email so that you may share them, share this information with them, because that session is very important. Here you hear about the substantive issues, and in that session you will hear about the more formal delivery aspects of what you should do or shouldn't do in the moot. So I invite you all on behalf of the speakers on that session as well.
Paula, do you have any other comments before we turn to Christina?
Just the last one, Cesar. First of all, thank you again for having me. And please let me once again underline, I think, the most important idea that we can have as a conclusion from today's session. When we apply international instruments, we have to switch off the button of our internal domestic law and systems. So this, we have to have an holistic, we have to think of an holistic application of all the rules in this instrument, in this international instrument, and we must switch off the button. This is very difficult. It just comes with the experience, but this is the right path to interpret and to apply an international instrument. That will be all. I would like to thank Ingeborg and Edgar for sharing this panel with me, and I will give the floor to Christina.
So we have come to an end of this wonderful session. I think this 2 events was really successful. Cesar, thank you for the partnership in going on. I have some ideas, and Cesar always helps me to put them in practice. And I also want to remind that, well, we are fulfilling the goal of the Vis Moot, but also from the Charter Institute of Arbitrators, because these are 2 institutions that have a long-lasting relationship. The Charter Institute of Arbitration is all of arbitrators, has also this goal of enhancing the use of arbitration and developing the professional skills for those that are involved in it. And we saw that this case will really rely on the skills of the participants, because there's no much case law, there's not much doctrine about the issues that are involved. So it will be very interesting to see how the teams present their cases and the arguments that will be used. I invite all the students that are watching us to join the Charter Institute. You know that students have a free membership, and it's always very interesting. You will learn a lot. And please follow us at LinkedIn. We will put all the important information that we're given today. We will post there about also the CISG International Conference in Guadalajara, and the pre-moot on the 10th February, and then the session of Professor Ingeborg Schwenzer and Louise Barrington involving the do's and the don'ts. So I will want to close this session today, thanking again for Ingeborg, Edgardo, and Paula for this wonderful sharing of information here, and to our audience, thank you very much, and follow us at LinkedIn. Have a nice day or night, or go on with your work today, and see you next time. Bye-bye.